bill that would ban most abortions in Ohio is now headed to Governor Mike DeWine's desk. He said that he will sign it. The controversial measure would outlaw abortions in our state after a fetal heartbeat is detected, which can be as early as 6 weeks. Both sides giving last-ditch arguments before the vote.
They agree that a child is a child when their heart is beating.
There would, at the very least, be an exception for rape or incest. But there are no such exceptions in this heartless bill.
The controversial measure would outlaw abortions in our state after a fetal heartbeat is detected, which we know can be as early as 6 weeks. We just told you. But 5 on Your Side investigator Scott Knoll, you talked to a legal expert today who really isn't convinced that this is going to make it through court.
Yeah, that law professor says there is no way the so-called heartbeat bill is constitutional. Instead, she believes the real goal here is to get it before the U.S. Supreme Court, hoping it can do what no other proposed law in 46 years has: overturn Roe versus Wade. Ask Jesse Hill what the heartbeat bill could mean.
I do not expect that it's going to take effect in Ohio.
In the Case Western Reserve University law professor says it's pretty simple.
It's clear that this law flies directly in the face of Roe v. Wade and is just obviously unconstitutional under existing precedent.
But Hill, who specializes in reproductive rights and constitutional law, says existing is the key word.
Opponents of Roe v. Wade are sensing that the time is ripe to mount a direct challenge to Roe v. Wade. So the end game here is, and it always has been, the U.S. Supreme Court.
She says that's because the court now has a majority of justices who favor overturning the controversial decision, essentially legalizing abortion. But first, it has to get to the nation's top court.
The Supreme Court doesn't have to hear this case. The Supreme Court is allowed to decide what cases it takes and doesn't take.
In the meantime, she predicts the bill wouldn't survive legal challenges at the trial court or even appeals court levels based on Roe versus Wade, the current law of the land.
The Supreme Court is the one court that can reconsider that precedent.
But will they?
If I had to bet, I would bet that the U.S. Supreme Court is not going to take a case like this.
The reason? She says it could come down to optics.
It would be too soon after the appointment of Justice Kavanaugh onto the court, and it would just signal too clearly that that change in personnel on the court has brought with it a change in constitutional law.
Now, what about a timeline? Well, first the governor has to sign the bill. Then there will be 90 days before it becomes law. That's when Hill expects lawsuits will be filed challenging it and asking a court to delay the law taking effect. Of course, all of this will mean a big legal fight. Something else to consider: Hill says if the state loses in court, taxpayers could be responsible for paying not just the state's lawyers, but lawyers representing the challengers in the case, too. Former Governor John Kasich vetoed the bill twice, citing concerns over those costs. Danita?
And Scott, similar versions of the so-called heartbeat bill have been passed in several states, including Kentucky, Georgia, and Mississippi. In Georgia, the state's governor has indicated he will sign it sometime next month. So far, none of the states that have passed it have been able to put it into lasting practice.